Welcome to Water Cooler Justice. I'm Chris Robertson, and I've been practicing employment law for over 20 years, helping clients resolve disputes or navigate challenges at work.
And I'm Sarah Goodenough, Chris's legal assistant.
So today we're going to be joined by an all-star cast of panelists, Ellen Lowe and Barry Fisher, two esteemed employment law professionals. Ellen Lowe started her career at Gallings, was later a partner at Whitten and Lublin. After a decade of practicing exclusively in employment law and HR relations, she started her own boutique firm, Ellen Lowe & Co. Employment Law. She obtained her law degree from the University of Ottawa in the Common Law (English) program and was called to the bar in Ontario in 2008. Ellen is a member of the Labour and Employment section of the Ontario Bar Association, Women in Law, Toronto Lawyers Association, and the Advocate Society. Ellen regularly represents her clients in court and at tribunals, but is equally well-versed in mediation advocacy, where she assists clients in navigating alternative dispute resolutions and negotiated settlements. Ellen is a friend, a colleague. I don't know if we've had many files together, but I know that when I can't remember a new case or an exciting case or an interesting case, the first person I call, who might have it at the tip of their tongue, is Ellen. And then we've got Barry Fisher, who I sort of think of as the Dean of Employment Law. He's a mediator and arbitrator in Toronto. The Barry Fisher blog is a must-read for anyone who's interested in employment law. He was called to the bar only in 1979. And has been an alternative dispute resolution practitioner since 1987. His practice focuses on both labor and employment law matters. He's the author of the Wrongful Dismissal Database, an essential tool for this practice. It was designed to assist lawyers and human resource professionals in determining reasonable notice. He's a distinguished fellow of the International Academy of Mediators, an organization of leading commercial mediators from around the globe. He is listed in the Best Lawyers in Canada, brackets 2008 to 2022, in the category of alternative dispute resolution. He's also been referred to as a leading member of the employment law bar in the Canadian Legal Expert Dictionary, or directory, I should say. Barry is a frequent presenter at seminars and educational courses on issues relating to employment law, labor law, and ADR. He's the past chair and current executive on the alternative dispute resolution section of the Ontario Bar Association and a current executive on the labor and employment section of the Ontario Bar Association. He's also a member of the Ontario Labour Management Arbitrators Association. Barry is the recipient of the Ontario Bar Association 2011 Award of Excellence in Alternative Dispute Resolution and served as co-chair of the Law Society of Upper Canada's Employment Law Summit for 10 years. Barry is also a very recent winner of the Randall Acklin Award. So welcome, guys. I'm super happy to have you joining us today. This is our inaugural session. Today we'll be looking at what I think is an interesting case with lots of different issues that arise frequently in employment law. And I can't wait to sort of have that kind of chit-chat that we often have when we're sort of gathered together privately and share a little bit of that insight with our listeners. Over to you, Sarah.
All right. So the way this is going to work today is I'm going to share a recent case. We're going to learn the details of the case, and at the end of each issue, we will discuss a fair judgment. I'm also going to share the judge's decision at the end, and we'll find out the resolution. Is everybody ready?
Let's do it.
So the year is 1994. Jimmy How Tein Fat, whom we will call Mr. How, an accountant from England, arrives in Canada. Upon his arrival, he joined PGRX, a global audit and advisory firm. He was amongst the first handful of employees at the company and has stayed with them for 29 years. Over his tenure, he received several promotions, a handsome salary, and generous bonuses. On June 13th, 2019, he was appointed VP of North American Operations and Global Audit Innovation. A loyal employee, PGRX was the only company that Mr. How worked for during his entire working career in Canada. He is now 63 years old. In 2022, Mr. How was let go by the company and as a result of structuring. He was offered 34 weeks, approximately 8 months of severance, which was the statutory amount that was required. So a little background about PGRX. It is described as a global audit and advisory firm providing expert advice, data analysis, and recovery audits. The company has grown since 1994 and now has 20 offices in various parts of the world. PGRX is described by both parties as being a highly specialized and niche market with very few, if any, comparable companies. This will be important for later. Now, a few quick facts about Mr. How's role in the company. So Mr. Howe oversaw the retail operations of Canada and the United States, which accounted for approximately 45% of PGRX's total revenue. Mr. Howe's base salary was over $400,000. In 2021, his T4 income compensation was over $1.2 million, which included his salary, bonus, deferred equity, and taxable benefits. And just as a reminder, Mr. Howe is 63 years old and was with this company for 29 years. So I'm going to pass it off to you guys here. So upon hearing this story, do you think that 34 weeks of severance is a fair offer?
Well, it's not even an offer. It was the statutory minimum, so it's not even fair to call it an offer. And I don't know if the company offered. Did the company offer him more at the time, or just pay him his 34 weeks with no offer? So usually companies in a situation like this would offer something, otherwise it'd be a complete joke. So I'm not sure we have all the data, but no, 34 weeks is not an offer. It's a payment, minimum payments.
Yeah, I would agree. Like, issues of asking for a release or anything extra aside, at first blush, listen, I have to work in months because the court works in months. So I have to be a nerd and do the math because I can't get my head around weeks. So
it's about 8 months, Ellen.
It's about 8 months, right? And so, listen, even if we assume it's not subject to mitigation, there's no reduction for future income earned over the same period of time. Let's say we give that a bump up of 15 to 20%. Well, we're still talking, what, 9.5 months or so? That seems really low to me for somebody who's 63 in a specialized field with 29 years of experience. I mean, absent other considerations like they're immediately going bankrupt, I don't think any of us think this is a serious proposal.
No, this is a plaintiff's dream. This guy actually walked into any plaintiff lawyer's office with no offer. The lawyer would be planning his cottage or his new car.
Right. 63, 29 years of experience, and they offered you baseline minimum compliance with the ESA. Yeah.
I had a guy similar to this years ago who worked, but they offered 18 months, which was, starting to get serious. But as I listened to the guy, he had told me he never took a vacation in his entire life. And I roughly calculated the vacation pay alone was about $300,000. He did actually help me buy my cottage.
Well, so I think there's always magic in the numbers too, right? Like if you see 8 weeks, if you see 34 weeks, these are obvious ties to the statutory minimums. And so, if you're a plaintiff sort of wondering, is the offer fair? The first question is, if it's under 34 weeks, is it just ESA minimums? And by the way, what a lot of plaintiffs don't realize, or a lot of employees don't realize, is, hey, they got to pay you that money right away. They've got to pay it within, I think, 5 or 7 days, and there's no mitigation, and it's got to be lump sum. If their offer has some sort of extended acceptance, or it purports to be salary continuance, and it's for 34 weeks, or less, I mean, as Barry said, that's a dream file.
I would go farther to say that no individual who's not a lawyer, and frankly, I go farther, no individual who's not an employment lawyer can properly assess the notice period. It's not a matter of asking your brother-in-law or calling the Ministry of Labor. And it's very important. I did practice for 20 years, so I'm talking both as a lawyer and as a mediator, and I was always shocked by the number of people who took advice from, quite frankly, complete idiots on what the notice period was. Their brother-in-law. My favorite one was the HR lady told me it was fair. Well,
I was going to mention that one. The HR person told me it's a fair and reasonable proposal.
She's always been a nice person.
To double check that it's fine.
Yeah. So it's way different than it was 20, 30 years ago. But for a modest cost or no cost, everyone should check out the notice periods. Even if the number of months is right, the components of that severance are probably, the benefits, the bonus. This is not easy stuff. And there's a lot of money that you could be leaving on the table. So,
yeah, I mean, again, to Barry's point, and with the weird sort of 34 weeks, which is a clear tie-in to the statutory severance, what a lot of people don't realize is that the ESA has a formula, and the formula calculates what's called a regular wage. The way the formula works is if you've recently received a large incentive payment, for example, a large bonus or a large equity cash payment, it can get dumped into that calculation. And so the pool of money can expand, and it's then divided by 12 to determine a weekly wage. And so what happens, I once had a case where the Employment Standards Act entitlements were over $1 million because a $500,000 bonus had been paid immediately prior to the termination. So even right there, and there's no argument about that. The employer has to pay that. And so, even right there, that's a good reason to get in to see an employment law specialist, because a generalist just isn't going to know that.
It's actually, you go back 12 weeks. You mentioned the 12
Yeah,
weeks.
that's right.
You
That's
do a
right.
12-week backward average, as I call it.
But that's a huge mistake that I see all the time.
Employers think it's 12 weeks base, and
It's not.
that's all and it would have a multiplier effect for this guy. Every week that was wrong would be multiplied by 34, so it could make a big
Correct.
difference, right?
Yeah, on this guy's file, I would be curious to see if they actually calculated it correctly when they made their initial offer. But I guess these are things we'll never see because it was a summary judgment and we don't have the affidavits.
Well, the other thing too is there's case law to say if the employer screws up the employment standards payment, either delays it or doesn't make it right, the employee often puts forward a claim for either bad faith or punitives or something, just to add to the dollar figure. So I think sometimes plaintiffs' lawyers look for small defects so they can claim punitive damages and everything.
Absolutely, yeah. I do.
Or aggravated for sure.
I could say in mediation it doesn't work, but it throws in a little wrench and embarrasses the HR person, so there may be some value there.
Well, I don't know about that. You can also just go to the Employment Standards Branch.
No, you wouldn't do that. You would never do that. If you file a complaint with the Ministry of Labor for termination pay, you are screwed out of wrongful dismissal action. That's actually an important thing. Do not think that filing a complaint frankly, don't talk to them. The ministry's useless. The people on the phone will say, that's true. The people on the phone will say, oh, you got your 34 weeks, nothing we can do about it. But if you file it, this is a weird provision brought in by, I can't remember, some previous government. If you file a claim for termination pay and you don't withdraw it within 2 weeks or 30 days, I can't remember.
30 days, I think it is. Yeah,
it's short.
30 days, which takes, they won't even respond in 30 days. You are barred from bringing a wrongful dismissal action. It's a interesting provision to exclude. So the Ministry of Labor, they're as useful as the DMV if you're trying to get advice on your employment law case.
I'd be slightly more pragmatic and say they're helpful. They're helpful in certain things. I know we're going to talk about.
No, they're good. And you know who they hurt even more? Employers. You get a small employer who calls up the ministry. They're told they only have to pay the guy 8 weeks. They don't know any better. They rely on this crappy advice. And then they get sued by guys like Chris and Ellen. So, no, they're of little use.
Well,
in my respectful opinion.
Right, but in fairness, I can probably come up with some circumstances where the monetary amounts or there's something specific to the file, it might make sense to go to the branch. But I agree, for the most part, Barry.
No, going to the branch after receiving advice, but relying on their advice or thinking that if you're $20 short on your termination pay, you file a complaint under the act. That would be a terrible thing.
Yeah, it's the reverse order. Don't go to the branch first. I agree.
Right.
Yes. Get counsel, explore options, debate merits of,
Sometimes going to the ESA is the most practical, but
yeah, for sure. Especially if you already mitigated, right? The guy's got another job already, and really all you're looking for is enforcement of baseline minimums. Might be a valid option.
You committed something which was really bad, but not willful misconduct. You can get away with a lot under the Employment Standards Act.
Guys, we've got I think 10 more questions on this one. This case is like a law school exam, so there's going to be lots of opportunities to talk about some of these other things as we come back around. Sarah, you want to take us into the next section?
Great. Yes, thank you. So it seems like we're kind of on the same page in regards to Mr. How, and he agrees. So he believes he is entitled to at least 24 months, and he came with receipts. So he backs up his claim with a list of 31 cases, which he says are comparable. In these 31 cases, each involved employees who had an average of 22 years of employment and were on average 55 years of age. The average notice was 24 months, And a second chart of 23 cases was provided that lists cases of employees who earned $275,000 or more. Based on this, we can see that the courts consider a higher level of remuneration as a factor that increases notice. PRGX submits that Mr. How is entitled to no more than 18 months, and to support this, they referred to only 3 cases, none of which reflect Mr. How's position or compensation. In one case, the employee was a 58-year-old foreman. His salary was $58,300 with no bonuses or equity. In another, the plaintiff worked for the employer for 22 and a half years. He was 47 years old when he was terminated and was earning $110,000 with no bonuses, no equity. He was given 16 months. In the third case, the employee was a customer service manager and office manager who was terminated at the age of 46 after 26 years of service. Her salary was nowhere near comparable to Mr. How, and she received 15 months. So the judgment here, based on these factors discussed and the multitude of case law that has been presented, the judge found that a 24-month notice period was warranted. So let's hear some of your thoughts on that.
Well, first of all, when it comes to cherry picking
I'll jump right in.
All right, you jump in.
Yeah, I'll jump in. I mean, my first instinct was at the age and with the length of service, maybe this is even exceptional circumstances. And so 24 months is the unofficial maximum. But I'm wondering, should it have been more?
Well, you've raised the issue of those 2 or 3 cases that claim that there is this mythical cap of 24 and we can go over when there's exceptional circumstances. The trouble with those cases, and I'm not the Court of Appeal because they did it, not me, is that once you've looked at what we call the Bardolph factors, age, position, years of service, that sort of stuff, to then reemphasize those again as exceptional circumstances always struck me as bizarre. He's an easy 24. My comment is more about how lawyers present cases. They all cherry pick. There's no way the average was 24, and these 3 that put forth by the employer are completely ridiculous. This is why there's always a range of notice. So what the best advice a lawyer can give is here's the range, and the range is probably 18 to 24. So surprise, the plaintiff always goes for the high point, the defendant goes for the low point, and most judges are hopefully smart enough and go somewhere in between. But be wary of a lawyer that tells you this is 22 months period, end of story. He or she is being over precise. There's always a range. It's not 12 to 24. But there's always a range, and different factors can happen, and so whatever. But this is 24. Yeah, this is an easy 24-month case.
Yeah, I agree. I think it's an easy 24-month case, and it's a trial decision, right? Like, this is the right decision at trial. Is it the right number in a settlement? No, probably not. But it's a trial decision. And so I was shaking my head, Chris, and you were talking about, like, is it exceptional? I'm shaking my head only because we have the line of jurisprudence that says that age and length of service alone do not equal exceptional circumstances. But that said, I do agree with Barry, and I have these fights pretty regularly where I acknowledge that that's what the Court of Appeal said in Daw, but also it's still supposed to be an individualized assessment with respect to all the different Bardolph factors. And so I suspect, possibly like Barry, if the average of the 31 cases presented by counsel came to 24, we're probably pulling some pre-Daw cases, and maybe a few of the post-Daw cases that exceeded 24 months, but there frankly aren't that many.
The other thing too is it's important not to overemphasize salary as an indicator. The Bardolph factors do not, they say character of employment. And there's a whole bunch of cases on this. And it is a myth to think that it used to be, quite frankly, what it was like secretaries got less than presidents because they're secretaries. They're not presidents. There was no logic behind any of this. And there's a couple cases that remind us that character of employment, first of all, is not automatic, and second of all, requires evidence, which is almost never done, which continually bothers me because lower paid wage people tend to get lower notice periods than higher paid people without any evidence whatsoever that it is easier or harder for that person to get a job. So what I would find more helpful here is not how much Mr. How made, because even some lawyers I know make that much money. Well, nobody in my family, but anyway. But rather this specialization and the fact that he's not going to be able to walk into another. There's not 100 of these jobs floating around. That's what I would be emphasizing, which frankly rarely is. They go to salary, they say, oh, it must be a limited job market because he's making so much money. With the false assumption that a 63-year-old tradesman is going to have an easy time getting a job.
Right. I had the same idea. I think I like that the judge leaned into the specialized nature of How's industry and his particular role. And so I think that was a real important factor in the judge's decision. And I agree on the character of employment. That's always been difficult to reconcile, right? Why a laborer should get less than 4 weeks or why a receptionist should get less than 4 weeks and a president should get more. And so, I think there is a line of jurisprudence, that's beginning to address that, but I think there's probably more work to be done there.
Well, there was one case in New Brunswick and one case in Ontario, and then it's ignored. I almost never see lawyers. I can't remember the name of it right now. Di Tommaso, right. I never see. And when I wrote a blog about Di Tommaso, and I said it works two ways, too. I mean, employers can use it to say, don't be mesmerized but that he's a president. Why should he get more? But it's very hard to bring forth evidence of how many positions are available. I've never found any statistical study about how long does it actually take a person to get a job. This is all anecdotal, which accounts for why there's so much continued uncertainty in ascertaining notice periods, especially for short service people. Most of the cases I see now in mediation are people of less than 5 years, because apparently this generation can't work more than 5 years at any job.
Whoa.
No, that's because the employers fire them, not because the millennials.
Yeah. There's a whole host of things going on there.
Because these companies are 2 years old. I've been with the company since its founding last week.
As a millennial, I'll do my best not to be offended by that comment.
Not your fault.
Sometimes you gotta move out to move up, right? Sometimes, you can't stay.
No, I know. But there's a reason they don't offer pension plans anymore, for God's sakes. Nobody's going to be working for these companies. But the unpredictability of short service employees is of no benefit to anyone. They're all over the map, from as high as 12 months for a year and a half, sometimes 2 months. And that's what I think the law is really going to have to face, because that's most cases now. There's not a lot of Mr. Fats anymore in the world.
29 years is pretty exceptional, and I can't think of that many cases off the top of my head where we're talking about 20, 22, 23, 4, 5, 6 plus years of service on a trial level.
Yeah, we used to. When I started, when you started, that was normal. People worked, and now the normal is, I was there 3 years, I was there 2 years, 5 years, I almost became president. And we haven't managed, in my opinion, the notice periods well for short service people, and they're literally all over the map.
Barry, I'm wondering, do you track in your wrongful dismissal database the short service notice periods by location? I'm wondering if people in Toronto get more notice and people in rural Ontario might get less notice.
I tracked it by province, not.
It would be interesting. It'd be interesting if there was a way to get down into that, because, of course, the cost of living in Toronto is going nowhere but up, and I feel that there's some correlation, at least in my practice, that I see with notice periods getting a little bit higher, particularly for short service employees. And it's because we've all got to pay rent, we've all got to.
Well, on the other hand,
lights on, right?
If you live in downtown Toronto, you have availability for potentially thousands of jobs. If you live in, I don't know, Kenora, there ain't a lot.
That's why it's a matrix, right?
Yeah.
There's a lot of moving parts.
Yeah, the isolation of the job isn't. But again, yes and no. If you're a hybrid at-home worker, it doesn't matter where you are. But if you are a tradesman, yes, tradesperson, then whether you're in Kenora or somewhere else, that's always been a factor. If you have a one-company town and you're fired from there, you're going to get a better notice period because you have to leave to get a job. The court acknowledges that.
Well, and also, conversely, for a mitigation perspective, you're competing potentially with the same pool of candidates for the same number of jobs, right? So the mill shuts down in Northern Ontario. There are only so many places for all of those employees to reemploy. And so, listen, if I'm on the other side, I'm certainly arguing it's going to take my guy a lot longer because that pool is significantly smaller. So we're looking at any economic statistics we can pull, we're going to pull that. reemployment, unemployment, all those stats.
I've never seen anyone pull out real stats in a wrongful dismissal case. In the
I've
olden
got a
days,
folder in my filing cabinet.
well, that's good, because in the old days, management would bring out some relocation hack who would say, "Oh, the guy should have had a job. It was useless." Judges ignored it, but it's hard to put together that evidence. I've never tried, but you would think Stats Can, for instance, wouldn't they have evidence of how long the average person takes to get a job? I don't know.
So we don't have a census anymore, so it's tough to get some of that detail. It would be nice to have.
Yeah, StatsCan does have some good, it actually does have some good real-time unemployment information.
I mean, a creative person could do it. You could look at EI. How long do people stay on EI? I don't know. There's ways of doing it, but the law ignores all that. We work on these assumptions, which are actually perhaps not correct. Older people have a tougher time getting a job than younger people. If you're 60 versus 40, yes, but you're a 22-year-old, you're going to have a very tough time getting a job too. We don't take that into account. So a lot of the Bardolph factors are frankly not well thought out. We just got used to them.
Know about that. I think one of the things about the Bardolph factors is it allows the courts to do justice as they see it, right? Advocates make the pitch and the judge makes the decision.
Yeah, but not every case is different. We have this myth that every case is different, has to be examined. People are fired every day, hundreds, if not thousands of people. I think we owe it to the public, who will put us all out of business, so that's why we're not in favor of it, to have some sort of meat chart, a fair meat chart.
No.
They'll never do it, so we'll still be in business. That's fine.
Well, it's interesting, though, and again, totally getting off topic, but there are, and I've spoken on this before, there are some, I think, genuine questions about the use of like AI and predictive analytics with respect to you input all of these different factors, we spit out a reasonable range, and now we're going to battle over what end of the range it should be. But some of the guesswork around where the range should be is taken over by, to some degree, weighted analytics and predictive metrics.
I think any decent lawyer can tell the range. Most lawyers are fighting within the range. Like no idiot, not even Mr. Fat's lawyer, not even PGX's lawyer said it was 34 weeks, right? So
right.
Don't get me started on AI and all that stuff, but a smart lawyer is better than AI, put it any day of the week.
Obstinate lawyer is harder to work with than a reasonably predicted range from...
Well, people can also use certain databases, you know.
I called you.
Hyperlink to Barry's database.
Yeah. I called you. I said, Barry, let's get some AI on this wrongful dismissal database.
No, my database relies on human intelligence, not artificial intelligence.
Fair enough.
I think that's fair, but and again, we're now wildly off topic, but this is how this works. Related but unrelated, can I make a small plug to talk to a human, though? Because I do very much get worried that people are inputting their information onto these bots on a variety of websites, and we all know sort of where they are and who they are. And then I get calls saying, I inputted my information and I know that I am entitled to X, Y, and Z. And that it's really tough because, again, it's like a reasonable human who does look at the data and the cases. Then I'm now managing expectations to say, listen, the database or the predictive analytics or the chat bot might have said 24 months, but that's probably not actually realistic in your personal circumstances.
I have a whole host of thoughts about those online calculators too, because they encourage you to consider your matter as a wrongful dismissal matter. But if you've been terminated after taking a lengthy leave of absence, or you've become disabled, or you've been on a parental leave, your case actually may not be a wrongful dismissal case. It's actually something else. And the processes and procedures in those other tribunals or other forums may be better for you. They may give you a better remedy. And of course, damages, I'll get off topic for a moment. Like damages are not taxable, and wages are taxable, and you have to pay CPP and EI on them.
It's not. Damages aren't taxable. Certain types of damages may not be taxable.
Fair enough. But certain types of damages that could arise in the claims that I described are not taxable. And so every dollar that the employer has to pay is a dollar in your pocket, right? That actually helps bridge gaps between parties significantly, because the tax rate for a guy like our subject today, Mr. How, is going to be 53%. So, again, start with a human. I agree, Alan. Start with a lawyer. then look at the online employment status.
Lawyer or a human? Oh, a human lawyer. I see what
A human lawyer. Yeah, a compassionate lawyer like Ellen or myself.
I see what you did there, Barry. I like it.
Yeah, I agree. Okay, Sarah, maybe let's drive on to our next question.
Perfect. Okay, so let's move on. So the next issue is damages under the notice period. So during Mr. Howe's employment at PGRX, a large proportion of his compensation was a bonus. Common law entitlement says that a dismissed employee is entitled to any bonus that the employee otherwise would have received. Now, this may be modified by contract. So any plan that awards bonuses must unambiguously remove the entitlement for it to be effective. So we need to take a closer look at Mr. Howe's employment contract and the specific language that was used. This is going to get a little bit tricky, so just bear with me as we go through. So in or around March 2016, Mr. Howe became eligible to participate in the Management Variable Plan, MVP, which provided senior employees with incentive bonuses. Bonuses were triggered by the company hitting various financial targets. In this case, Mr. Howe was entitled to receive an objectively calculated bonus payment targeted at 50% of his base salary, but which could pay him up to 100% of his base salary based on hitting these targets for both the entire organization and his department. Based on this, Mr. Howe's bonus for the 2022 fiscal year is calculable. In cross-examination, Ms. Howard, Chief Human Resources Officer of PGRX, testified that Mr. Howe, being employed at PGRX at the time the bonus was awarded, he would have been entitled to $260,133. So basically, based on the 2016 MVP bonus plan, Mr. Howe was entitled to a $260,000 payment. But PGRX claims to have documents that disentitle him to a bonus, and he was no longer a current active employee. In 2019, Mr. Howe was provided with a new offer of employment letter tied to his most recent promotion. The letter sets out his continued entitlement to participate in the PGRX bonus plan. When Mr. Howe was dismissed in 2022, the plan described an eligible participant as follows. Number 1, is not eligible to participate in any other incentive plan or program of the company unless written terms of that plan extensively permit participation in both. Number 2, is in a regular full-time position unless otherwise required by law. Number 3, is in an eligible position on or before September 30th of the plan year. Now, keep in mind, Mr. Howe was dismissed in July 28th of 2022. Number 4, is not on a performance improvement plan or other written warning. And number 5, is employed when the bonus is scheduled to be paid. So I'm going to pass it off to our panel. Based on this, was Mr. Howe entitled to the bonus during the reasonable notice period? And if so, do the terms of the contract or bonus plan unambiguously take away or limit that common law right?
Well, there's two types of bonuses that play in here. What I call the stub bonus and then the notice period bonus. The stub bonus, I'm going to assume that it's, it doesn't matter. Let's assume it's a calendar year bonus or September to September. He worked part of the year. So the first issue is he entitled to be paid for the time that he was actually there? The second one is he entitled to be paid over the notice period? And what portion of the notice period? Is it the whole notice period or is it affected by other factors? Ellen, I just wanted to make that one comment.
Right.
No, I think that's fair. And in both instances, both stub period and applicability over the reasonable notice period, I am going to vociferously argue, yes, he should be getting it. And again, there's a bunch of different reasons or ways that you would look at that. I mean, one, you're probably going to look at the contract enforceability itself, right? So was this a properly construed policy? Was it put towards them? Were these terms brought to his attention? All that sort of good stuff. And then, Barry, to your question on sort of how long do you get it, you're probably digging a little bit into compliance with the Employment Standards Act. So if it's, quote, employed when bonus is scheduled to be paid, is that a failure to pay wages? Does that breach the ESA? If that breaches the ESA, does that void the whole thing? And And then as sort of the second part of the question, what I call sort of exclusionary clauses, right? The assessment of the actual language itself. Does that unambiguously take away or limit the common law right? These are hard. These are hard onuses. These are difficult things to show. So we know that the exclusion clause has to cover the exact circumstances as contemplated. We know that it can't just be, quote, terminated. We get a lot of information from the jurisprudence with respect to what this is going to look like. And I'm going to argue that the threshold is getting kind of higher and higher, especially if we're looking at things Matthews post and post Matthews, that sort of the reference to just limiting rights to common law notice may be required in addition, in my view, to just saying you can't get damages in lieu with respect to sort of the period of notice. So again, looking sort of those at the specific restrictions of the rights and the specific language and enforceability of the contract in and of itself.
This is in many mediations, and we argue over the language, whether the language is sufficient, whether the language breaches the various, usually the Employment Standards Act. For instance, one of the provisions that often employers screw up is it'll say something like your active employee, your entitlement to a bonus terminates on the day you're terminated. Well, that offends a certain section of the Act, I can't remember, that says you have to keep all terms and conditions the same for the termination period, which would be maximum 8 weeks. But employers are getting smarter now, so I'm seeing a lot of clauses which says redefines active employment as the later of your last day of work or the end of the minimum statutory period. So then plaintiff lawyers think up some other excuse. One argument which has not, I don't believe, been tested by the courts, and Ellen mentioned it, is the fact that certainly the stub bonus, what I call it, is an earned bonus. And if something is already earned, then it falls within the definition of wages under the Employment Standards Act. And there is no language on the face of the earth that can deprive you of your wages. So this is an argument I hear in mediation. I'm not aware of it being tested in the court. But that would mean that the language is irrelevant, at least for the stub, that you earned it. I mean, I had a case many, many years ago, again, when I was acting as a lawyer, where this guy had a huge stock option vesting occurring on Friday. He's going to make like, I don't know, $250,000 or something. And on Wednesday, he sits down with the HR person and they fire him. And he knows these guys. So he says, hey, Fred, to the HR guy, I'm sure you don't know this, but on Friday, I get a big chunk. Can we defer this meeting till Monday? And the HR manager leans into him and says, don't you ever assume I don't know exactly what day of the week it is. And it's like, what? So, wow. And that's where it really hits too, because, you know, the person's been there, they wined and dined him to come join the company. It's all about the bonus. You have organizations like financial institutions where the base salary basically pays for your parking. And you get one huge bonus at the end of the year. Oh, you weren't here on the day we paid it out. Yeah, because you frickin' fired me before. So there's this certain injustice, which I think judges look at, and that's where they try to use many technical rules to get over it. So in a situation like him, like this guy, where 2/3 of his income is variable income, the employer is going to have a hard time saying, you know, 24 months of base, which would, in this guy's case, would be like what, 8 months of things. So never lose track that most judges, with some exceptions, are humans with human feelings, and they try to do justice. So they will bend over backwards sometimes to make sure something happens that they want to happen.
I think that's absolutely right, Barry. The thing that I took away from this case, or that I found fascinating, was that the evidence was so inconsistent on the bonus point. You know, in their calculation of damages, the employer included the payment of bonus, but then they wanted the bonus excluded. You can't have it both ways. In their affidavit, they provided information about how Mr. How was not an executive by describing when he received the bonuses and how he received the bonuses like the other executives. It was very odd. It was almost as though the affidavit was prepared without sort of understanding what the viva voce evidence would be. And so in this case, what I found was that on each issue, whether it was the bonus, whether it was the character of employment, the court was really looking at what was in writing in the affidavit and not so much what was being said at the actual trial itself. And so I think that really informed the damages decision here.
The other thing that comes up in bonuses often, like this fact situation makes it clear that it's objectively calculated. Not all bonuses are like that. They often have a huge element of, discretion, that it's not just math-based. So those are harder ones too. And the other thing that always happens too, because normally I'm often mediating cases well before the notice period is over. So people are talking about what the next year is going to look like. And every employer is going to tell you that, this year's a disaster, it's going to fall apart. And every plaintiff the guy hasn't made a sale in 5 years, but 2 days just before he was fired, he's going to make the biggest sale of his life and everything. So we spend a lot of time on that. Now, trial judges don't have to worry about that because God forbid, by the time you get to trial, your kid's probably grown up and gone to college and got married. But anyways, you could not get to court these days before the end of any notice period almost. But when I mediate, it's normally 6 to 8 month range. So we're doing a lot of trying to figure out what would happen in the future. And that's where a lot of trade-offs come off too.
And on that, you'll note in this particular case, they use sort of the 3-year average. And to your point, Barry, I have a lot of conversations pretty regularly that it's not always or by default a 3-year average. It can be an acceptable rubric in terms of trying to quantify what that might look like over the reasonable notice period, but it's not set in stone.
No, the average is used. There's a case called Chan versus Royal Bank of Canada, which I'm very familiar with because I unsuccessfully mediated it, where the court said, if we have the actual data, we're going to use that. So in that case, it was quite interesting. It gives you some idea. The judge spent about 80 pages coming up with this formula, which frankly I came up with the mediation, but what the hell, I'm only a mediator, not a judge. RBC had a bonus pool of, say, $1 billion the year before he was fired. And the year after he was fired, their bonus pool went down to $800,000. So the judge said, fine, you get last year's bonus, less 20%. Kind of practical. I'm not going to try to figure out all these individual aspects. So that's one way of doing it too. So you'll see plaintiffs will often ask too, well, what did my comparables get? What did the other vice presidents get?
Yeah.
And you don't need to have the data. You don't need to know that John got 50,000, Mary got 60. You do it on a anonymous basis, and you just look at the percentage differences. So you say, given what my cohorts made last year, how did it change the next year? And then you'll see everybody got more than 10%. It went down 20%. There are creative ways of taking the guesswork out of figuring out future bonuses.
Yeah. What I'm wondering is, on the 3-year average, if the bonus is calculated by reference to the salary, I'm wondering if in your practices you see some kind of adjustment for year 1 and year 2 to reflect a calculation against the salary at the termination date, because you know how salary goes up over time. 2%, 3%, 4%. So on a bonus like this, though, right? What's 4% of $1 million? I like 4% of $1 million.
If this bonus was big, that's a fair comment. It's usually the increases haven't been that much. That's why it's important. Also, don't look at a T4 average, because a T4 average will pollute it down because of the base. If the base goes up, and his base could go up and his bonus could go down. So I always ask the employer to separate and tell me what the 3-year history of the bonus is, not necessarily the T4. So these are,
right. Those year-end pay statements are super helpful for that to show year-to-date.
Yes, if you don't have a T4, the T4 of assessing, because the T4 takes into taxable benefit costs, use of car, personal. It's a very useful thing, and you can't really fight over it. That's what the T4 says, for God's sakes. We spend a lot of time arguing over whether the guy gets a gas allowance or not and all that stuff.
The other thing I was wondering, in this case, they got vacation pay paid on the bonus.
Yep.
Thoughts on that, right? Any thoughts? Vacation pay on statutory notice versus vacation pay on statutory severance versus vacation pay on...
Well, in Ontario, if not all of Canada, the law is pretty clear now that the Employment Standards Act requires you to pay vacation pay on all bonuses, not just the severance bonus. This guy theoretically could go back to conceivably to the beginning of time. That's a whole nother issue. Unpaid vacation pay on variable income is a massive case. There's huge class actions about it. A lot of plaintiff lawyers forget about it, which I scratch my head at. It's not my job to remind them. there can be a lot of money. You can probably go back more than the limitation period because of what's called the discoverability rule. You relied on the honesty of your employer to pay, and now you're finding out they didn't know. And they often didn't know. It's not even being dishonest. They just didn't know. And there can be a lot of money. To say nothing else of the fact that the company is somewhat scared that if this case goes to court and they got to pay this guy a bonus, what about the other 900 people who got bonuses?
Commando, I agree.
It is an issue that a lot of lawyers don't catch. One of the fights I always hear is it the statutory rate of 4% or 6%, or is it the actual rate? So the guy had 4 weeks vacation. Is it 8%? The fight's within the fight, so to speak.
Sure. And then was there a greater right or benefit pursuant to Section 5 of the ESA? What I thought was interesting in this particular one, back to your comment, Chris, about this being like a law school exam, was like, was he entitled to the vacation pay? Was there a miscalculation? But you'll recall in this case, he didn't even know that there was a possible entitlement to it, I think, until discovery. So it wasn't until discovery that someone clued into the fact that he hadn't properly been paid vacation. And so my position on that, I think, was the same as Barry's, which is kind of his discoverability would probably be linked to when he first discovered that he had the ability to claim that, right? So knew or ought to have known, which doesn't trigger until quite later. But then there is sort of those 2 interesting discussions, right? One about Evangelista number 7, which goes back to the very beginning of his employment, which I like because it's a court of appeal decision. But I know, Barry, you've also written about, the Mazanak versus Bill and Son towing. It's a 2021 decision. You talk about blog, and I pulled it because it actually is contrary to Evangelista number 7, right? So the upside for Evangelista number 7 is it's a court of appeal decision, and it does go back, right? Allows basically the calculation of public holiday and vacation pay all the way back to the beginning of his employment. But the more recent decision, this 2021, Mazanak and Bill and Son, suggested differently. Effectively, the judge, in a very short explanation, found that the Limitation Act restricted claims for unpaid vacation 2 years from the commencement of the claim. Like, he couldn't go back to the beginning of his employment. He could only go.
I don't know whether that lawyer argued the evangelist the case. I don't know.
Yeah, again, it could be factually different. But I know that I have in my practice had that one. I have had that more recent case sort of thrown in my face in response to my very polite request for a full accounting with respect to historical vacation pay.
It can be, it could scare a lot of employers because they didn't know about it and stuff. And quite frankly, when I practiced, nobody even thought of that. I'm not sure who thought the argument up, but it apparently has been endorsed. So,
right, and it's a multiple across every employee, right? So if you've got 10 Mr. Howes working for you, it's not $60,000 in vacation pay; it's $600,000. If you've got 1,000 employees, right, and watch out, contingency fees are legal in Ontario, and class actions in employment law go together.
There's multiple class actions on this issue already. Yeah. There's one. I'm not sure which bank, so I won't say, but I heard the story is the class is all people who've received bonuses. Well, everybody on the executive, including the chairman, received a bonus. So it'll be interesting to see whether the chairman and the president and the CEO opt out of the class action.
They probably have the highest claims.
Oh, they probably turn around and say, well, I'm going to opt out, but I want to guarantee that if they get paid, I get it too or something. Who knows? But it is something that should normally unite all. And it's very hard. Like in Ontario, you have to do the purchase. You can include it in the commission. It's funny. 25 years ago, when I represented car dealerships, I identified this problem. And they said, oh, it's going to cost us 4% more. I said, no, it's not. Right now, you're paying the guy $100 for every car he sells. Right. Change your commission plan. You pay him $96 to sell the car, and you tack on the vacation pay. So with a little bit of wording, this can be avoided for the future. Now, having said that, the employee has to consent. And in Ontario, this is a tiny little rule that costs one of the banks a lot of money. You also have to separate the 2 payments on the pay stub. So when you're paying the salesman the $100 for the car, it has to say $96 for selling car plus 4% vacation pay. You get their consent and you do it that way, you've avoided the problem. So once they realize what the problem is, smart employers could rewrite their policies, basically reducing the bonus by the amount of the vacation and then adding it back in. And the employee's not going to care. He's getting the same amount of money.
Yeah, they got to make it clear. You have to paper it correctly, and then it's contractual.
Correct, right. But again, under the Employment Standards Act of Ontario, you have to separate it by line. Other provinces don't have that. Not for statutory holiday pay, though. Only for vacation pay. Another reason why your barber, your friend, your brother probably is not the best person to give you advice on employment law.
Well, $60,000 on this judgment may not seem like a lot because the judgment was over $1 million, but $60,000 is a lot of money, right? That's going to be your legal fees, and even in a case like this, deep into the litigation process, right? A good lawyer can make a business case for litigation if these mistakes exist. And I think employers owe it to themselves to get to the bottom of it and fix their pay stubs.
The one other thing about vacation pay, which I often hear, you do not get vacation pay on your severance pay, though. There's three components of a typical package: termination pay under the Employment Standards Act, severance pay under the Employment Standards Act, and common law. You do get your vacation pay on the termination pay, but that's a maximum of 8 weeks. You do not get it on severance, and generally speaking, you're not entitled to it under your common law aspects either.
So that's what I was trying to drive at earlier. Sarah, I think we've covered some of the later topics, so I just want to hit mitigation. We're coming up into the end of our hour. I do want to talk about mitigation a little bit. And just for listeners who are going to be joining us more regularly, if you had a good time this time, next week's case is going to be almost exclusively about mitigation, so we'll really get into it because I think you've started to hear in our conversation today how it's such a difficult area for the employer to prove. And we'll talk about the test a little bit in a moment, which I think is really fascinating because I think there's a super low bar and then there's a super high bar. And it works in a way that is maybe a little unfair to one of the parties. All right, Sarah.
Great. So before we jump into that, let's just get to the judge's decision on the bonus, just so the audience knows where we're going. Yeah, we're good.
I think I let the cat out of the bag, didn't I?
I think you did, yes. So essentially, for the purpose of calculating wrongful dismissal damages, the employment contract is not treated as terminated until after the reasonable notice period expires. So before we go into mitigation, Chris, why don't you say or tell us in your own words, or if you could define what mitigation means?
Mitigation is really about the search for alternative comparable employment. There's a two-part test. One, whether the employee's efforts were reasonable, and two, whether the employer can demonstrate that alternative comparable employment or comparable alternative employment could have been found. And so for me, it's a fascinating test because I think the bar on the first hurdle, the bar for the employee, is a very, very low bar. And I think that the bar for the employer on the second test is either a very, very high bar or a very, very difficult bar to meet, evidentially speaking. And so I'm sort of fascinated, but let's get into the story of what happened here, Sarah.
So PGRX asserts that Mr. How was in a very niche business market. And so they were very surprised that he didn't look at their direct competitors for employment opportunities. In his affidavit, Mr. How described PGRX as being in a highly specialized and niche business of performing recovery audits for some of the largest corporate retailers in the world. The next closest competitor generated only 30% of PGRX's revenue. Mr. How further testified, for the most part, there are no available positions at other companies that operate in my specialized field. Given the specialized and niche nature of the market, PGRX argues it was unreasonable for Mr. How not to have made a targeted search of their competitors. As part of his affidavit, Mr. How provided a detailed chart setting out his mitigation efforts, including lists of people who he spoke to in search for employment. This chart, unfortunately, did not satisfy PGRX. So Mr. How then contacted the competitors they listed off and unsurprisingly came back with no job offers. So going back to the panel, do you think that Mr. How did his best to mitigate?
He doesn't have to do his best. It's the wrong question. He doesn't even have to do average. He just basically doesn't have to be a disaster. Reasonable is viewed as a very low bar.
Can I give you my favorite? My favorite of all time is a case called Huxco, which is from 2020. I refer to it regularly when opposing counsel is being cute with me about mitigation efforts. And I like to cite it to them because I am not kidding you, but the plaintiff literally built a sailboat rather than look for jobs. And the judge decided that that was entirely fine. The defendant had still not discharged its burden of proving that even if a reasonable job search had been made, the plaintiff would have found another job. So this sort of older person who had always wanted to build a sailboat have at it. Like, I love that so much in response to all this sort of garbage
I would not
around.
recommend a client to build a sailboat, but
I appreciated his honesty, which was that he had done literally nothing, entirely failed to make reasonable efforts because he was very busy building a sailboat.
I hear those various excuses all the time from plaintiffs, like my mother died, so I couldn't look for a job for 3 months. I used to tell my clients when I was a plaintiff, I don't care what you do. I mean, if you play golf with Trump all week. Every week you crank out 5 job applications, okay? That's it. It is so frustrating for plaintiffs' counsel when their client can't do the simplest task of pretending to look for a job. And employers will utilize that. They'll send lists. They'll send, here's 50 jobs you should apply for. It's the game back and forth. Even if there's a terrible failure to mitigate, some judges articulate it, some don't. Sometimes when you see a case and, gee, that's a cheap notice period, you read it through and you realize the guy did bugger all. I used to have a test. If the plaintiff was over 55 and he moved from Toronto to his cottage and immediately used his severance pay to winterize his cottage, and the only jobs he's applied for was a golf starter or Canadian Tire, he's probably not looking for a new job.
Well, there's a whole host of things there too. Like, for example, a lot of jobs don't have the compensation band posted with them. I tell my clients, apply for the job, and if the compensation's well below such that it's not alternative comparable employment, you're done, right?
There's no excuse to not apply for jobs.
But then track it, like track your efforts.
For God's sakes, get off your derriere for 5 minutes a day, especially on the internet, and make your lawyer's job easier.
Right. And I tell them, go to the interviews, right? Because even if it's something that ultimately in the interview process turns out to be, again, not comparable, you're still interviewing, you're practicing, working on those skills. And it just takes away any ammunition that the employer might have at mediation for, trying to get a lower settlement. Why give them something to complain about?
I had a case at the beginning of COVID. Just before COVID, this company fired a general manager of a franchise restaurant chain because he was lousy, but, not just cause lousy, just lousy. And then COVID hit. So we're doing the mediation about 6-8 months into COVID. And defense lawyer is saying, our company's being devastated. We've closed 2/3 of our stores, blah, blah, blah. And then 2 seconds later says, well, why hasn't he mitigated? I said, because he's lousy and 2/3 of the stores are being eliminated. He said, yeah, I guess you're right on this one. So it's with some lawyers, it's just axiomatic. But if you want to make your plaintiff's lawyer's job easier, just look for a job. Who cares? You probably won't get one, but just look.
Hey, let's flip on our management hats for a moment. Okay. How does an employer actually demonstrate that a job opportunity actually is evidence, a job posting is evidence of comparable alternative employment?
All right, so what does an employer do? An employer provides a very good reference letter without being asked.
Yeah.
An employer might provide for relocation counseling without being asked. An employer might actually pass on job leads, real job leads, not, a half-paid job in New Brunswick or something like that, and actively helps the person get a job because it is in their interest. It's in everyone's interest, other than the contingency plaintiff's lawyer, for the plaintiff to get a job quickly. And I do not understand why employers block it. They allege just cause when there isn't any. They refuse to give reference letters. They should be encouraging the person to get a job because that'll lower their liability and also makes the employee feel better. Oh, I've been laid off, but they're giving me all this help. And
they don't hate me after 29 years of service.
Yeah, they're not so nasty. And you look better in court.
100%. Right. I got my plaintiffs to track their job search efforts. I got my employers to track what they've done to try and help this individual because absolutely we're going to rely on it.
And the other thing, if you get to court and the notice period and the mitigation is fine, defense counsel should stand up and say, we are not contesting mitigation. You do not want to hear the plaintiff go on for 3 hours about how horrible his life has been. You take it off the table and say, we're not going to be arguing over the notice period and the entitlements, but this person did sufficient so that it's not an issue. You take it off the table. Don't attack the victim. And then if they start leading evidence, you say, Your Honor, and the judge is going, listen, it's not an issue. Move on to another topic.
So last thing, Barry, there was a case that talked about employers having to send the job postings over contemporaneously while the postings were open, right? And that's so that the plaintiff's lawyer can't cross-examine on the job postings. Like, do you know if the position was filled? Do you know what the compensation was?
Well, no, also,
was the position filled by an incumbent, right?
Well, there's no point sending a job, like, why didn't you look at this? If you really want to make it, you send it to the plaintiff's lawyer every week. Here's new jobs opportunity for your client.
Right. So I think, Sarah, we're coming up on the end of our hour here, and our esteemed colleagues do have lives and practices that they have to return to. And so maybe now is a good time for us to just sort of wrap up. I did want to say thank you to both Barry and Ellen for a super entertaining conversation and a super insightful one. And there's lots of good information in here for employees and employers, right? And it's not hard. Right. But the problem is, you're only coming to the lawyer when you've got a problem. Right. This podcast is an opportunity to just listen to how things are done, what the prevailing thoughts and trends are, so you can get ahead. Right. Proactive employers and employees are, I think well served by these kinds of conversations. And I just want to say, Ellen, while you were just off screen there for a moment, I want to say thank you very much. It was super fun. I had a great time. I think I laughed a lot. I apologize if my laugh was a little loud. Yeah, tune in next week for a more somber podcast. There'll be no laughter. And we'll talk about mitigation.
Yes, thank you. Thank you, everyone.
Bye,
Thanks,
everyone.
Ellen.
See you, Barry. Nice to see you.
Thank you very much, guys.